Angela Spencer versus Harrison County, 22-40548. You may proceed.
Thank you, Your Honor. May it please the court. Counsel. On behalf of a student, a young man, A.S., and his mother, and my co-counsel here today for his first time in the court, and let me share with the court, I'm getting a little bit older, so I'm trying to help mentor some of the younger attorneys. We thank the court for this opportunity to speak on behalf of not just this case, but really, I think, a very, very important issue. And as I was contemplating our discussion today, it's a phrase that you sometimes hear, but it really sounds like this may be a case of first impression. We're here on behalf of a young man who suffered what we believe was an unconstitutional seizure. He was shackled by his legs while in juvenile court. A restraint, we believe, violates the Fourth Amendment to the United States Constitution because it was, and still important then, and it's important now, because it was done without due process of law. I'm not too sure how many more times I'm going to be before the court, though I'm going to be practicing law for a long time, I hope. But I want to start, every time there's a pleading that we give before the court, it ends with a conclusion and prayer. So I'm going to kind of start with that. And my thinking and my prayer is that nobody really believes that shackling a 10-year-old kid in court is the right thing to do. Now, we're here to talk about whether it's constitutional or not. But I wanted to start off with that because I think by the time I'm finished in the next 20 minutes, I'm going to bridge that right thing to do with the constitutional thing to do. The other thing I'm more than happy to do, because I've been here a number of times, if you have any questions, feel free to ask them right now. My time is short. I know that you know the case. I know that you've read the pleadings. I know that you've read the law. You're familiar with all that stuff. So if you do have any questions, I'm happy to answer them now. And if not, I can obviously go forward.
Premise for the question, we need you to convince us that the Constitution would require the relief that you want.
Well, that's a fair start, and that's a good segue, Your Honor, if you give me a moment. So I would argue that the plain language of the Constitution itself gives us that basis. And I'll read it, even though it might sound a little bit redundant. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, are particularly describing the place to be searched and the persons or things to be seized. Now, we know that the early decisions related to the amendment did not apply to the states. And then later on in Mapp versus Ohio, via the Due Process Clause, it did. We also know that over time, even though the specific language of that just talked about secure and seizures of property, et cetera, over time it clearly means the seizure of a person, the unreasonable restraint of a person anywhere. Now, I believe my colleague will talk about, why they should win. Of course, we're the appellant because the district judge found for them, and also because, going exactly to your question, Judge Southwick, there's no case law specifically on that. There's no case that says that. Well, part of what I'm saying is there has to be. But because the plain language of the statute says that, one, people can't be seized by the government. The second part of the phrase means without due process. Now, it's talking about probable cause and other things, but clearly it translates to other parts of our life to meaning due process, which of course is what we argued. We also know children can't be seized or restrained at school. That's clear. There's case law all over that. The Fifth Circuit case law that says that too. So from where I sit, I think it is not a far jump, and that fact, in fact, there is the Constitution itself on the plain language, and the case law says that it extends to other areas. We know it extends through the Supreme Court case of New Jersey versus TLO. We also know that it...
Best case for a constitutional violation in the context of an initial detention hearing before the judge only.
That's absolutely correct, Your Honor. The case law that the Harrison County has presented to the court actually makes that distinction, and they believe that, and I think that the magistrate and the district court affirmed with that particular statement that you only have this right, or a child can only have this right during what they call the critical stage, during a jury, and not during, just being presented in juvenile court. Of course, if we look a little bit deeper and scratch the surface and look at the case law that says that, it does say that there's no constitution. Let me make sure I phrase this correctly. It doesn't say that there's a per se constitutional right to be free from restraint in juvenile court, without a doubt. What it does say is that if you're going to restrain a kid in juvenile court, you have to make an individualized assessment. So I want to be real clear about the issue of whether or not there's a jury or not. By the way, once again, the case law that the county has provided throughout almost every single case answers your question as well, that before you're going to restrain a child in court, you have to have an individualized assessment.
Before the judge only?
Yes. So I want to be, I want to be clear also. Our original pleadings talked about the restraint from the detention center to the courthouse. That's no longer in play. We're only talking about when they're before the judge. And we think it's important to note...
Why would you draw a distinction between those two periods?
I'm sorry?
Why would you draw a distinction between the two periods?
Because the issue of the transportation started at the detention center, which related, in my estimation, to an Eighth Amendment case, and I thought that would be much harder to make, just to be frank.
Well, no, I get it, but just from a common sense viewpoint, I can understand, and let me just tell you, I acknowledge shackling a 10-year-old, it is pretty shocking. And you'd like to think that that would never be necessary anywhere, but we have to deal with the reality of the world, unfortunately. Yes, and so I get the common sense of the detention center, because you are transporting presumably a group of people who something's gone wrong, and you want to make sure that they don't hurt each other, that they don't run off, that kind of thing.
Well, that's exactly correct, and that's why we dropped that argument, because the case law that was put together, presented by the county, pretty specifically discussed the transport from the detention center to the courtroom, and obviously, for all the reasons you just enunciated, the transportation from the juvenile detention center to the courthouse itself is fraught with a lot more possibility for elopement and danger or this or that. Once someone's in the courtroom, and we cited in our brief in a footnote to what the record reflected of how many people were in the courtroom, the idea that somebody was going to elope while in the courtroom with all those people, particularly a 10-year-old, particularly someone who the record reflects, and in fact the county admits, had no problems while there. Now, if we had a child that, God bless them, arguably was dangerous, and they fought people, and they were running away all the time, then, we wouldn't be here. But as a matter of course, we had a child that even, I believe, the pleadings show as an admission that he wasn't really dangerous at all, didn't really need to be there. I mean, it's not even really...
How was he prejudiced?
I'm sorry, Your Honor.
How was the boy prejudiced during the
Absolutely, Your Honor.
detention hearing?
The issue of the term prejudice as it came up in the case law has to do with prejudice during a criminal court proceeding or a juvenile court proceeding. The issue of injury, a constitutional injury, is different. He doesn't have to show he was prejudiced. He just has to show he was received a constitutional injury, which of course we argue he did. And as a related vein...
What is that injury?
I'm sorry, Your Honor.
What is that injury?
The injury is one of a dignitary harm, which is assumed anytime somebody suffers a constitutional harm. The case law is pretty clear, and we've kind of enunciated some of it, that when someone experiences a constitutional claim, they can even get nominal damages. They don't have to show any other damages.
It seems that the principal case law you have for us, it's not from other states, state courts, is due process and effect on fact-finding by, where the fact-finding is that somebody being shackled must be dangerous, therefore more likely guilty, whatever the crime is. So that's the due process violation that the case law supports. Seems to me your claim is quite different from that. It's almost a liberty interest of not being shackled without some sort of individualized determination of the necessity for it. I haven't looked at the state cases beyond what you say in the brief and your friend on the other side statements about them. Is there any way that this issue has been reconceptualized from due process that might help you?
Well, obviously, after being here today, I probably want to consider it. But
no, in the case law, is any that you've been citing to us, take this outside of this sense of affecting guilt and innocent determination to just the right of people, not particularly a child whose dangerousness you would like to think is less and the need for individualized determination greater, as reconceptualize that from due process into something else?
my answer to that's probably limited based upon my background in the law, but my impression of using a liberty interest, I usually use when I'm dealing with a pure 14th Amendment due process issue. I don't think I've ever used it or really thought about it until you're asking that question about using it as part of the Fourth Amendment, because I think the seizure, to say someone's being seized, doesn't that really imply a liberty interest anyway?
Well, this person has been seized already in the detention facility.
Yes.
Proceed. We don't need to
Okay.
hypothesize too much here.
Let me see. Just a few brief points, since I only have 2 minutes left and I have 5 minutes later. I think the county has some pleading issues. I don't think they've addressed in their motion for summary judgment initially our Fourth Amendment issue, and I think there's a fair question about that waived. I think when we filed our response and they did a reply, once again, they did not address the Fourth Amendment issue directly. I think that's an issue of consideration. Sometime later, they brought up an issue in the appeal court that there was a distinction between the county judge and the county policy, and I think that's an infirm argument. I mean, the record's replete with the county policy being one of shackling kids, both in taking them to the detention center and in court. And in any case, they're the ones that applied the shackling, regardless of whether it was the judge's policy or not. So they're responsible for it.
Does the record show a written policy?
Yes.
It is a written policy?
Yes, it's in their own, the county's own handbook. They had a memorandum where they addressed that issue very, very specifically.
Policy by the juvenile board or by the juvenile judge?
It doesn't really distinguish it. What it does say is that it's the juvenile Juvenile Justice Center memorandum policy.
Well, back in 1996, we held in Flores that it was the juvenile board was the official county policy maker.
Yeah, well, two things there, Your Honor. One is that the memo that I'm cited to was from 2015, and arguably, if there's a distinction between whether it was the county judge or the county, that's an issue of material fact that should be saved for the jury. That's a contested issue right now. So if nothing else, I would answer you that procedurally, that also saves us. Thank you so much for letting me be here today. We'll be back in a couple minutes. Thank you.
All right, Counsel, thank you. Please.
Good afternoon, may it please the court. My name is Casey O'Neill, representing Harrison County, Texas in this matter.
Are you in private practice? Are you the county attorney, or?
I'm private practice. I'm actually, Robert Davis, who handled this case previously, was set for trial today, and so he asked me if I could come learn the case and come and have the honor to speak in front of you, in front of my colleagues today. So I'm really excited to be here. As we've already touched on, it's a case of first impression. Both sides have admitted there's sparse case law out there dealing with the shackling of...
In what sense is it a case of first impression? I'm not sure I follow that. There are cases about shackling prisoners.
Yes, Judge, there are. And I guess what I'm getting at is that the way we view this case is the appellant is seeking to sort of do two things. One is trying to create a new category of a constitutional protection for juveniles in the early stages, in the non-adjudicatory stages of the juvenile delinquency process, and then go a step further and create a civil cause of action based on that constitutional violation. The cases that do involve it pretty much are all in the criminal context. There's a handful of cases that involve shackling, one of which was cited by the appellant in this. It was Youngblood v. Romero, and in Youngblood it was a issue where it was shackling in a mental institution for somebody who was committed, and it was done for punishment reasons. Ultimately the case had to do with an injunction for violation of policy, but that's really about the only shackling case that either side is discussing.
Well, there are cases about restraints in front of jurors, right?
Absolutely there are.
Southwick already alluded to, and I'm familiar with those cases.
Right. And so ultimately with that is that those all are dealing with a question of, is it going to affect the presumption of innocence? Is it affecting the ability to communicate with counsel? Is it affecting any kind of biases by seeing this? And that's a whole separate issue of trying to say, well, there was an error in court, potentially a reversible error in court, whether or not there was bias or something like that. And so therefore now we should be able to have a cause of action against the county for actions that happened in the courtroom. And that's where we kind of consider it, uncharted waters at this point.
Also, it seems to me, if we're not in the arena of affecting the presumption of innocence, which is a nice label to put for the overall problem of doing it in front of the fact finder on guilt and innocence, then it's just a continuation. I'm not disagreeing with your colleague opposing counsel dropping the shackling earlier than entering into the courtroom, but it seems to be of a piece with that, which is the purpose of it is restraint, is to keep a prisoner of whatever age from being a flight risk or whatever else. So it seems to me it's tied closer to the shackling of anybody, starting back at the detention center and transporting them. Just where does that rationale end, and some need for a new rationale to begin? That's not to say that the earlier shackling's all right. Shackling's all right. It's not in this case anymore. But I'm just wondering if it's really distinguishable, because what we're really talking about now is restraint. And does the environment of the courtroom provide enough restraint that rationale doesn't apply anymore? I mean, my colleague here may not want to call it a case of first impression, but is a case of some additional impressions that have not been dealt with too much before.
Well, I think that's a great point, and you touched on in your questioning with my colleague about where is the distinction. It's all one policy. This is how we're going to transport. This is what's going to happen.
So you get shackled back at the detention facility, and those same shackles continue, or is it just ankle shackles once they get to the courthouse?
So the process essentially, once they go They remain in shackles until the courtroom is clear of the adults who are also using that courtroom. At that point, they will bring them in and they will remove, I believe they remove the belly belt and the handcuffs just prior to entering the courtroom. And then the ankles remain on under that blanket policy when the judge is doing the preliminary hearings. And that's one of the points that we've made is, I mean, it's a very preliminary stage. You know, some of the case law has discussed the juvenile civil rights and things like that. For example, Galt, which is one of the kind of key cases that was cited in. Pardon my notes, I got out of order here. But Galt was one where they were trying to figure out about. We understand that in juvenile delinquency, they're not afforded all civil rights. In Galt, they expanded that right because what the court recognized was that had the individual been 18 years old, what he was accused of doing carried a fine of $5 to $50 in 2 months. Instead, because he was a juvenile and found guilty, he was committed to about 6 years in the state system. And that's where they were like, okay, something's not right here. In this preliminary status, this is way outside the context of something like Galt, where, you know, in this short hearing, which ultimately he was released. I don't think there's any showing that he was prejudiced in any way. He was, you know, released by the judge. It's completely different than some of these other cases where there's a huge protection that we need to get at. And again, most of them are all dealing with the criminal aspect, not civil cases. And so that's kind of where I think we take a monumental leap in order to, you know, one, create, in our opinion, a new category of protection, but then create a civil action for that, and the potential ramifications that, as I mentioned earlier, you could have any other sort of reversible error that comes up to open the door for other civil actions based on, you know, this opinion.
Was there anything in this case that was introduced to show how widespread such a practice is in Texas? I mean, I'm saying it's necessarily relevant, but it strikes me to some extent the way it struck Judge Duncan. It seems a bit surprising that this would be the policy. So was there any effort to show that sound like you came to the case late, that you're aware of, to show this has been done widely in Texas?
As far as within the court system and the blanket policy, I don't know, Judge. I do believe that it's in the record that it's a widespread policy for transport. That's actually in the case law as well. I mean, it's common sense that during transport, you know, there would be restraints on, you know, the people going to and from the detention facility to the courthouse.
Remind me what ended this? How did this child end up in the juvenile detention?
So, like, what was he accused of doing?
What did he do?
It was an altercation with a teacher at his school, and during the dispute where they got the school, I believe the school resource officer, if I recall correctly.
You got in a fight with a teacher?
Well, I think there was some scratching or something along those lines. I don't want to go so far as to call it a fight with a teacher. I believe it was
2 staff members is what my memo says, but something like that. 2 adults worked at the school.
correct. Hands were put on somebody, but
Violence involved?
I'm sorry.
Violence involved?
Not that I can tell. But again, as I've said, I'm coming in late in the process, so I was not there for the depositions. And
How much notice did you get?
not a ton, Judge. I got the green light, I believe, last Thursday that I was coming. So,
Welcome.
You're doing well.
And to the point earlier that my colleague was making about looking at this policy, the question about whether or not the policy is constitutional is a complete different question than if it should be revisited for other reasons, fairness, does it make sense, is it overbearing? that's a different than the constitutional question of what we're addressing here today. And I mean, I feel like we've kind of belabored the point about, you know, the juvenile is treated different than the adult proceedings. And then early on, there's the cases that have discussed that in the early stages where we're not in the adjudicatory part of the process, then there are other rights not afforded. For example, in Pew, which is a U.S. Supreme Court decision, it gets into the probable cause hearing, and it says, you know, look, there are other constitutional protections during a probable cause hearing that you're not afforded. I mean, courts have made the distinction between early process in the decision and then ultimately deciding this, you know, we're going to punish this person. And that's where they've drawn the distinction on the constitutional line in that. Other than that, subject to any questions, I concede the remainder of my time.
You got one more question. Here it comes.
No. I was making a remark to Judge.
This is not
I'd
something.
like that stricken from the record.
Counsel, appreciate your assistance with that.
I appreciate the opportunity. Thank you so much.
We found your argument helpful.
Thank you, Your Honor. Hope Robert's paying you a lot of money. Thank you. Couple fact questions.
So can you tell me, how did this child end up in the juvenile
Yes, I
detention
can.
center? What
That's
happened?
exactly what I was going to speak to first, Your Honor. The record reflects he was 10 years old, he was 75 pounds. When I tell folks about the case, he was the poster boy for ADHD. He was cute as a button, and he was just bounced all over the place. He had special education services, which is in the record. He had what they called a behavioral intervention plan, which is supposed to deal with his behaviors. And something else that's in the record that, since you asked, I have to bring out, his mom really advocated pretty heavily for him, and the record reflects that when he turned 10 years old, one of the staff members said, well, now he's old enough to be, you know, charged in criminal court, because in Texas, you've got to be 10 years old before they can charge you. So there was a little bit of a fair question about how appropriate that was, and I'll ask the court to take judicial notice of the underlying case in the district court where we sued the school district for that, and we had a settlement, Your Honor. But in any case, what happened was he was restrained, he pushed back, he evidently scratched one or two people during it, and they filed assault on a public servant, and they brought him to the detention center. Personally, I find that troubling too, but not illegal.
What happened after all of this? Did anything else happen after all this in the system?
He happens to be a great kid.
That's not a great way of asking the question.
But I do want to answer Justice Wiener's question, maybe
Yeah, sure,
tail
go
onto that too. So in our brief, our reply brief at paragraph 32, we cite a Supreme Court case and even a Louisiana case here that talks about that a person is entitled to compensatory damages for violations under the Constitution because it's an injury unto itself. Carey, which was Carey versus Fifus, obligates the court to award nominal damages when a plaintiff establishes a violation of his constitutional right, and this is a key term here, Your Honor, but cannot prove actual injury. So I wanted to answer that question.
I'm sorry, could you repeat that again?
Yes, Your Honor.
The hearing is not great.
I understand completely. It's in paragraph 32 of the appellant's brief, Your Honor, but it's a case called Carey versus Fifus, 435 U.S. 247. Carey obligates a court to award nominal damages when a plaintiff establishes the violation of his constitutional right but cannot show actual injury.
Okay.
I think it answers that. So I'm going to take one last risk. I went to law school when I was 39. I graduated when I was 41. And my last class was a trial advocacy class with a Judge Rickoff. Some of you may remember him. He was kind of iconoclast in San Antonio back then. And he went around the room and he asked everybody what they learned in class. Just so happened I was the last one. And I said, Your Honor, what I learned in class from you is not to let the law get in the way of what's right and wrong. And he looked at me and he said, Mr. Cirkiel, you're going to get an A in class. And I said, thank you, Your Honor, that's my first day in law school. But my real point about bringing this up now is that I'm going to ask you to do somewhat of the same thing, not to let no law get in the way of making good law. Thank you for letting me be here today.
All right, counsel. Thanks to you both, those who have lived with this case for a long time and those who have not. Appreciate the assistance. And those who have never appeared in court before and have witnessed this, not sure what your expectations were, but this was a fairly standard argument. Thank you. We are in recess until tomorrow afternoon at 1 o'clock.